When my stomach started getting upset, then I knew I was getting close to a number I better not turn down.
Hi, everybody. Thanks for joining us. Today, we're going to speak with mediator and fantastic trial lawyer, Eric Ivary. He's been awarded the Alameda Contra Costa County Trial Lawyers Association's Member of the Year Award because of his excellent work throughout the years in the legal community. So we want to find out a little bit more about Eric and his path to becoming the mediator at ADR Services. So Eric, welcome, and thanks for taking the time to join us.
Yeah, well, thanks for taking the time yourself.
And we also have Ethan Niedermeyer, who is a fantastic attorney as well, who's going to be participating in the interviews.
And you'll catch the highlights of this interview. Sherrod's going to be typing it up for a verdict article in our next issue.
All right, Eric, first of all, let's start with how you decided to become a trial lawyer. When you were a young person, what was it? Was there some experience that you had or something that led you to the law?
Well, my father was a lawyer, but the kind of law he practiced and all his friends practiced was of no interest to me. And so when I got out of law school, I didn't want to teach English or do something like, I wanted to do something that I considered important. But the trick was finding the right area of law. And I found it by accident, really, by stumbling into a courtroom where Bruce Walkup was trying a case. And I had heard great orators like Marvin Lewis and Melvin Belli, and I figured I can't do that. But then I heard Bruce Walkup, and I thought to myself, I can do that, because he didn't hardly make a single objection. He was very soft-spoken and extremely well organized. So I thought, boy, that sounds like a good niche for me. So I got a job in a PI firm that already existed. This is 7 years before I joined Gary Gwilliam to form our firm.
You were already in law school when this happened, or was this before law school?
No, this was at the end of law school when I was on a summer break, I think, before the bar exam.
So was it the fact that your dad was an attorney? Is that something that at least pointed you in this direction, or was there some other thing?
My dad kind of did me a favor because I was an English major. And like I said, I didn't want to teach English. So he said, well, why don't you go to law school? And I said, well, what for? He said, well, it can't hurt. So if you're going to go apply for some job, if you have a law degree, it'll be a plus over the next guy. So that's kind of the way I backed into it.
Once you saw Bruce Walkup and thought, okay, I can do that, what did you do to kind of get on the right path to becoming a trial lawyer?
Well, I first got hired as an associate in a PI firm. It was a law offices of Alfred R. Knappen, N-A-P-H-A-N, in Oakland. And he was a very experienced trial lawyer. And I tell the story that I learned everything I knew about how to try a case from him. And then I also learned from him everything I found out about how not to try a case. Same guy.
Well, that's good that he covered both ends of the spectrum for you.
He certainly gave me a full spectrum.
So what were some of the things that you learned? Let's start with things that you figured out not to do. What are some tips, if there's younger lawyers listening to this, that they could pick up on?
Don't object. It makes it look like you're hiding something. Now, I'm talking about courtroom stuff right now. There's a lot more to it because cases are won in the preparation and in telling a story and in planning how to tell a story so that it has suspense. And that's true even if you're filing a mediation brief. You want to have the reader reach the conclusion, not reach it yourself.
Don't object a lot. Do you mean so if all these lawyers who will object to every question that you ask, either in depo or in trial, that's not a good tactic?
The ones that do it in depo, we call them litigators. Litigator is a guy or gal who takes a lot of depositions, makes 1 million objections and 1 million motions, and then when you go to the trial call, they're nowhere to be seen. You get the senior partner. They're gone. Once you get to trial, there's a whole set of strategies there. And that was a trial and error experience for me because I've been doing it long enough that the technology and the science is all changed.
The best way I've heard it described was by my mentor, Bernie Siegel, who said to me that there is a technical and tactical considerations when you object. Are you technically correct and tactically is it advised to make that objection? And you need to be able to make that determination in a split second. And a lot of the time, the answer is no, keep quiet and let it go instead of drawing attention to it.
My default was let it go because I had the experience in one of the trials I did that the defense objected so much, the jurors just got annoyed and the thought that he was just trying to hide the truth. I mean, what is it you don't want us to hear? That immediately focuses on the subject matter that you're calling attention to, which you think is objectionable. So that's all that's going to do is draw a circle around it and emphasize it. So my tool was always, if I can live without it, live without it.
Now, as far as your work is concerned, tell me about your trial work and how you got into that track. What was that? What were those experiences like, and how did you end up trying your first case as a first chair?
My very first case that I tried, I was the only chair. So I got thrown in like, a week after I got sworn in and tried a rear end auto accident case with a neck strain, and fortunately somehow won it. And sometimes I've learned through the years, a lot of times the cases I won, I really at the time had no idea why I won them. I only thought I did.
How did you work on your skills and improve your skills as time went on?
Very slowly, trial and error. We're all on some kind of spectrum. Even as mediators, we're on a spectrum from facilitative to dogmatic at the extreme end. And so the learning curve as a trial lawyer, it's really experiences of your life, and to remember that you've got somebody's life in your hands, and the consequences of what you do are really important. I was nervous before every single trial I ever had, and I had quite a lot of them. I lost count a long time ago, but the skill level is one that evolved with education in trial, and certainly
I was talking to somebody else about this, and I thought the worst thing that can happen to a lawyer is that they put on their suit and lose their humanity. And it sounds like that's what you're talking about, is bringing your humanity to the table makes you a much more effective advocate in the courtroom and for your clients outside of the courtroom.
Being a human being has to be your first default if you're on a fence. That's more important than how you look, because trials these days, cases are won in the preparation of the story and how you're going to deliver the story and what media or mechanism you're going to use. But before that, you've got to select a jury, and that's all science unto itself. You're not selecting a jury that is going to relate to you and your case. You're going to select a jury that can be persuaded by each other and in little blocks of people and see how they fit in, because this is a human exercise. Even though there's science to it, you're dealing with human beings. They have to want to do it and see it as the right thing to do. All juries that I have experiences with, including cases I've lost, they try to do the right thing. No matter what the judge says, they try to do the right thing.
I think that goes back to the fact that as advocates, we're dealing with human beings on both sides of the aisle. And the worst thing you can do is lose sight of the fact that there are other humans on the other side. And I've heard trial lawyers say, well, I'm a trial lawyer, I convince juries, but isn't our job to convince the defense lawyer and the adjuster and the mediator? And if that doesn't work, then you go and try the case and you convince a jury.
That's one of the reasons part two of my career has been in ADR services as a mediator. And I don't even see a conflict in what I'm doing. I'm trying to help people on, like you said, both sides of the aisle. And on the insurance side, they have different interests, but they're the same human beings that we are. And they're affected by the same things we are and persuaded by the same things we are. They just have a different template or analysis and different vocabulary sometimes. But that's not as important as the humanity part.
Yeah, and I think that's one of the great things that you do as a mediator is that you ask tough questions in both rooms, because both sides have to really critically evaluate their positions and come to the conclusion that the settlement is the best thing for everybody involved. And you do a really good job of asking questions so people get to those conclusions on their own rather than simply just forcing them to a position that they don't agree with, which is a lot harder to do.
My technique is to ask questions, not make statements. I'll make a statement if somebody asks me, like asks for a mediator's proposal. That's a form of a statement. But I tell the plaintiff's lawyers when they come in a couple of humorous sort of things. And one of which is I tell them, look, it's my job to settle cases, but it's your job to settle a good case. I'm concerned only with a mutual settlement that's agreeable to both sides, and you're the arbiters of that. And it doesn't mean I don't have an opinion. Of course I do. Everybody has an opinion. But you got to keep that to yourself unless somebody asks you.
Now, you've mentioned several times that as a trial lawyer, preparation a lot of the times and the storytelling wins the case. I'm assuming that that's also true for mediation. Now, is there anything you would say to attorneys who are coming to you to help them resolve cases that they should consider and do better, or others who have done things really well to position their cases for settlement that you've seen over the many cases that you've mediated?
If I could sum it up to one thought, it would be this. Before you embark on the whole enterprise of a mediation and start writing that brief, picture who is your audience? Who is your target audience for what you're writing and what you're saying? It's not a neutral third person. It's the other side of the case. That's who you're writing it for, because those are the people that ultimately have to be persuaded in order for there to come together to be a mutual assent at anything. So to me, you're not in a trial. This isn't a trial brief. Skip the argumentative stuff and just remember what would appeal to the other side of your case, whether you're on the plaintiff or the defense, that would get them to be cooperative rather than combative about the whole process.
Along those lines, are there any things that are absolutely required that you see in your mediation briefs that you want every plaintiff's counsel to include or every defense attorney to include? And then when you talk about writing towards an audience, are you talking about writing towards an audience of the mediator, defense counsel, the adjuster? What audience do you think is the best one to address in a mediation brief?
The one that's most important to keep sight of is how the other side, your adversary, is going to react to what you write. Do you ever try to insult somebody and then ask them for money? How does that work? Really
Not very
great,
well.
Huh? No, on the plaintiff side, that's certainly what I would advise is keep that front and center. The mediator, mediators get used to everything. They see it from one end of the spectrum to another. So that's a less important audience because the mediator's not supposed to be an outright advocate, but you don't want the mediator getting in the way of you're getting the case resolved for how you want it, because sometimes it's a tall order. If I have to mediate a really, really big case, I have to hopefully, for your sake, help convince an insurer that $10 million is a great settlement for this case because it's a real bargain. And sometimes $10 million is a real bargain, but you have to approach that slowly, and you cannot do anything too fast. Don't rush what you're doing, let it evolve. That's why most of these take a whole day. It's a process. It's not science.
In that context, what have you seen attorneys do that is particularly effective in communicating and creating an atmosphere that's productive for these discussions?
Well, first and foremost, starting with a settlement demand that in numbers tells the other side you're here to actually settle the case, not just make a statement or an argument about how great your case is. Give them a demand in the range of something that the case could actually settle for. Obviously more, give yourself plenty of room, but don't put it in the stratosphere to start out because A, it won't help, and B, all you're going to get in reply is an equally ridiculous offer, which is going to be nothing more than an insult, which makes the mediator have to start all over again.
Let me play devil's advocate on that point for a second. In that context, I've had this discussion when I was doing defense work, and that is if you've got a plaintiff's lawyer that comes in at a super high number, the defense is like, oh, that's ridiculous. Why are they coming in that number? And then if there's a plaintiff's lawyer who comes in at a number that's super reasonable, the defense sees that as, oh, we can squeeze them some more and get this for even a cheaper price than we thought we were going to get. How do you deal with that situation when it happens?
I assume an insurance company and adjusters and people in that profession do their job pretty consistently, and bargaining is always in their toolbox. It's inevitable. You're going to get that. So get over it. That always is going to happen. The key is persist in the range that you think is reasonable. You don't have to make these gigantic moves that so many plaintiffs' lawyers don't like to have to do, because you started with so much air in your balloon. It takes a long time to let it all out.
Now, let me ask you this. You've now been an advocate and a mediator. What would you say are the similarities and differences between being a trial lawyer and a mediator?
Not as big as you might think. I think they're both ends of a spectrum that we call justice, and part of our justice system. And like I said, I view my role as a mediator as an extension of my role as a trial lawyer, because I'm part of a process, and I'm trying to deliver something instead of by fiat and a jury, by mutual agreement. So the biggest challenge for me is to help people see what's in their own best interest. And in order to see what's in your own best interest, you have to be able to look ahead. Insurance companies are professional at that, and they're quite good at it. They seldom come in without doing a risk assessment. The plaintiff side, sometimes not so much. But the plaintiffs, most of the time, this is the only case they'll ever have in their life. So literally their whole life depends on the decisions that they make. So my job with the plaintiffs is make sure that they understand the importance of the decision that they're making, and that they're not walking away from what really they might think in a different time is a good deal as opposed to a bad one. And the big advantage, I think, for the plaintiff is you have certainty of the outcome, which you do not have with a jury trial.
Yeah, and I think one of the things that I've experienced that you do very well is to allow the parties on both sides to look at the problem from all angles and make informed decisions. And the way I couch it is, we don't want a situation where anybody leans over and says, well, what just happened here? And I think you do an effective job in facilitating that conversation in a productive way, as opposed to one where people are getting upset and feel standoffish about it.
There's the old adage too that sometimes, the good result, neither side is happy with, right? And a lot of what I'm hearing from you, Eric, is that, you're that gap between the two opposing sides, and you get them to agree on something. What are the tips or strategies that you use to bridge that gap so everyone's unhappy?
I want the total process by the end to be a relief to both sides. Nobody's walking on air necessarily, but they're relieved by the outcome. My objective in every mediation, and I tell people in advance, this is my only goal, is to settle cases. Not get you a good settlement, just get you a settlement. The good part's up to you. In the process of doing that, my goal by the end of the day, at 5 o'clock or whatever, is to give both sides a hard choice. They came in there with an easy choice, demand, offer, screw you. That's the easy choice. The hard choice is one where you really got to think about it. And that's where, my past experience comes in, because I went through that process many, many times. And I know when my stomach started getting upset, then I knew I was getting close to a number I better not turn down. So you have to actually feel this as it goes along.
Looking back at your career, what are you the most proud of in terms of your accomplishments, either as a trial lawyer or as a mediator?
Well, as a trial lawyer, I had a couple of very, very large verdicts, but those were part luck. I'm more proud of the cases that I've settled for families that made a life-altering difference for them in their future. And sometimes with a lot of adversity, they had to go through a lot of adversity to get there. But that is a worthwhile task for me on every level.
I always think about mediation, when you're mediating a case as a mediator, people come to you, maybe it's 5 or 10 or 15 people that are involved in that process with a problem. And if they leave with a resolution, that as a mediator, you've done something to put good in those people's lives. And that's worth a lot from a professional satisfaction standpoint, I would think.
Yeah, that's exactly what I mean by that. I'm doing something socially good, a good outcome because it's a peaceful outcome, it's a consensual outcome, it's by an agreement, and both sides manage to do this without going through an adversarial process. Sometimes the adversarial process is the only way, but it can be satisfying just as much for me now to get a result that makes a life-changing difference for somebody or a family. There's a lot to be said for that.
As we wind down our discussion, is there any advice you would give to young lawyers who are coming up in our profession, whether they're on the plaintiff side or on the defense side, in terms of things they can think about to have the kind of longevity and success that you've had in your career?
I'd start with a concept that's relatively new in the law called civility. And by that I mean civility was kind of built in when I started, not anymore. So yeah, I have 2 rules in my mediations. Besides that, I have no rules. The 2 rules are confidentiality and civility. And so I would say as a starter, just be civil with your opponents, no matter what, no matter how rude or uncivil they may be with you. Don't let yourself get demeaned and into a battle of sniping and insults, and always tell the truth. You got to be able to tell the truth, because even in a trial, there's 12 jurors. Out of 12 of them, if you're not telling the truth, they'll notice. So it's kind of the same way in a mediation. You really can't fake it with all the eyes and ears you're going to have on you for a whole day. And the other thing that I have, it's an interesting concept, is it's very hard for a mediator to sell the other side of your case on something the mediator doesn't believe him or herself, okay? So no matter what we mediators say about being neutral, we're really not, because within ourselves, we already have formed an opinion about a case or a reaction to it, at least viscerally. And so, we carry that in there, whether it's a bias or an implicit bias. I like to make the effort to make every single implicit bias I have explicit to myself, not to the world, but to myself, so I can see what role it's having in what I'm doing. Okay, so that's the key. And I've focused a lot on the plaintiff side, but on the defense side, there's a real art. I don't preach to the defense about the cost of defense. How much is it going to cost to try this case? They already know that. They don't need to hear it again from me. They can hear it from you. But I don't want to waste any of my credibility lecturing them about anything. It comes up anyway, because sometimes I might ask them to, let's do a trial budget. Or another thing that I found helpful with mediation on the defense side is have them fill out the verdict form, not you, them. And they can put any numbers they want in there, and they know whether they're telling themselves the truth or not. But it goes to the exercise of analyzing a case in terms of the damages that are there that a jury is going to assess. That's what they're going to face if they don't settle the case. So for me, that's a great template for analyzing risk.
I want to thank you for taking the time to talk to us. And Ethan, thank you for joining us as well. And we really appreciate all your hard work and everything you've contributed to the greater legal community. So thank you very much. Appreciate it.
Thank you, Shar. And Eric, thank you again as well. Really appreciate everything. And you're a pillar for all of us in ACC TLA. And congratulations on your award.
Thank you. Appreciate you guys.